Hello and welcome back to my channel. My name is Gavin Fish and I'm very grateful that you stopped by. Today we are continuing our look into the case of the death of Gabby Petito by, we believe, many of us, myself included, by her fiance, Brian Laundrie. And specifically what I want to do is take a look at questions that I keep seeing posed in the media and in my comments section. The number one question that I have seen is, why hasn't Brian Laundrie been charged in Gabby Petito's murder? So we're going to get into that. We're going to get into a couple documents that I have prepared for you over here. If you are new to the channel, you haven't subscribed, and you think that I've deserved it, and if you like this kind of content, please do subscribe. I do ask that you like or dislike the video, depending on how you feel about it. I don't mind dislikes at all. It helps me know what kind of content you guys want to see. Okay, so the first thing that I want to do is let's just dive into the question, why haven't police charged Brian in Gabby's murder? And this has to do with probable cause versus reasonable doubt. Police and prosecutors have a symbiotic relationship with one another, but they have very different bars that they have to reach in order to make an arrest and successfully prosecute a case. Prosecutors are always looking for police to do that which will make their job easiest, and police, their main motivation is get the bad guys off the street. Now, one of the documents that I prepared for you guys to take a look at today is a document from another case that I'm following. Well, not just following, like really investigating. I'll put it in the description below. If you've been to the channel before, you know about this case. It is the case of Amanda Winkowski. Now, in this case, there were so many documents to go through, over 1,800 pages of documents to go through, and I found a document that was written by an investigator. It was actually a captain who was an investigator to his superior, asking for a little bit of latitude. Now, this is in the Buffalo, New York area. The police department is the Buffalo PD, and the meeting that he was going to is with the district attorney. So let me just go ahead and show you this document, and we'll talk a little bit about probable cause versus beyond a reasonable doubt. Okay, so this was written by a man named Michael McCarthy to Daniel Durenda, who I believe Mr. Durenda was on the, he was a police commissioner. Okay, he says, "Sir, Chief Richards and me will be meeting with DA Frank Sedita and ADA James Bargnesi, along with several of their investigators this afternoon." Keep in mind that in district attorney's offices, they also have investigators. Typically, or sometimes, they are retired police investigators who then go and work for the district attorney's office. So once a case is handed over to the DA by a police agency, the DA then needs to do some investigation, okay? This meeting was requested by the DA's office following the Buffalo News article that was obviously perceived by the DA's office as derogatory. I respectfully request to speak on behalf of the BPD regarding specifically the arrangement that developed over the years that now has our department requesting when we can arrest an individual. I believe that we must work together, but we have different thresholds for arrest and prosecution. Police threshold for arresting individuals is probable cause. The DA needs beyond a reasonable doubt for conviction/plea. This idea that we would work in unison years ago is something that is necessary, but the pendulum has swung way too far in that we now need their authorization and permission to make an arrest. This must change. He puts must in caps. We will continue to work together on cases, but they will not dictate how our department operates. I respectfully request permission to change this unwritten policy and alter this arrangement to a more reasonable agreement. I will await your decision. Thank you for your time and consideration of this very important matter. So this police officer, Captain McCarthy, is feeling frustrated, or was back in 2013, because there had become an unwritten rule that the DA's office was kind of in charge of whether police could make an arrest. And there's a good reason why the DA would want that, and I'm going to show you another document on that, but you can see how it can go a little too far. In the case of the Buffalo Police Department in 2013, he's saying that they needed the district attorney's permission to make an arrest. And we obviously don't want, I personally don't want a police system where the police on the ground have to ask permission to do things that are within their statutorily given power, right? But I also want to take a look at the district attorney side of this, right? And let's go over to, actually, I'm going to go to federal code because in the case of Brian Laundrie, we're talking about federal code here. The state code on this usually matches it pretty well, but not always, okay? And this has to do with time limits and exclusions. This is U.S. Code Title 18, subparagraph 3161. I want to go to paragraph B that says, any information or indictment charging an individual with the commission of an offense shall be filed within 30 days from the date on which such individual was arrested or served with a summons. Okay, so basically what that says is if you arrest an individual, you have 30 days to file charges against them. And if you don't, they go free unconditionally. So that is something that can really scare off prosecutors from making an arrest. Now, in the case of Brian Laundrie, they did a very wise thing in that they indicted him of a different crime, right? So when they indicted him of that crime, they made it possible. Let me open this up real quick. I'm looking for the indictment right now. That I think was on, goodness, there's the indictment. Okay, so the indictment came on September 22nd, and they indicted him on basically fraud in using Gabby Petito's debit card. Okay, so by doing that, when they do arrest him, they can file charges on this crime and keep him in custody. They can do it very quickly, and they can keep him in custody so that he never goes free again. If I were a prosecutor on this, I would be concerned that he was a flight risk because he has taken flight. Okay, now let me go back to the other part of this that makes prosecutors worried about making an arrest, and that is subparagraph C1. In any case in which a plea of not guilty is entered, the trial of the defendant charged in an information or indictment with a commission of offense shall commence within 70 days from the filing date and making public of the information or indictment. Now, this is actually pretty different from most states. Most states require that a trial begin within 180 days. The federal statute says within 70 days. That means the prosecution has to be ready within 70 days. Which on a case like Gabby Petito, I would understand their concern of being able to build their case within 70 days. Now, this is what is known as a defendant's right to a speedy trial. That's the part of the code that we're in here. And most defendants, at least defendants who get good attorneys, waive their right to a speedy trial because they want time for themselves to build a good defense. But that still is a concern that prosecutors have. They have 30 days to file charges. They have 70 days in federal court to actually, to commence a trial. That's basically what I'm getting at. Okay, so that, I believe, is the main reason why police haven't charged Brian Laundrie with the murder of Gabby Petito. Now, let me go on to the second question that people are asking all the time, and that is, why haven't police released a cause of death? Now, remember that they have released the manner of death as homicide, and manner of death is one of 5 things. It's natural causes, homicide, suicide, accident, or pending investigation. Those are the only 5 choices. So by telling us that it's a homicide, we do know that it's not one of those things. We can, I guess, argue that it might be manslaughter underneath a homicide manner of death. But what we don't know is the cause of death. Causes of death are things like gunshot wounds, strangulation, things like that we see in true crime all the time. And they have not released that. Now, why is that? Well, in speaking with some investigators, you guys, I showed you in a couple of videos ago, I interviewed Corey Jennings, who's a retired investigator. And several months ago, my friend Rick and I interviewed Detective Joe Cephalou, and they both said the same thing, that they withhold that stuff, those pieces of information, even from the defendant, because when they interview that person, if that person slips up and says, I didn't strangle her, or I didn't shoot her, or anything like that, then they didn't get that information from the police. They got it from the actual, I guess, commission of the crime, right? So they're very, very careful about the things that they release. Now, in some cases, they will release a cause of death publicly. I know of one case, in the Alexis Sharkey case, they did release the fact that she had been manually strangled. I think they were kind of forced to do that because there was so much other evidence that had made it into the public domain. In this case, I'm not sure that they're going to release that, except that we have seen photographs of the crime scene after the FBI left. So we believe that there's probably a gun involved, so they might release the cause of death, but I really, I think it's kind of a 50-50 shot. The next thing that I want to talk about, and I have a document prepared for this. Actually, I want to go into another question that keeps coming up in the comments, and the question is, what are the repercussions to Chris and Roberta Laundrie if they are found to have been accessories after the crime? Now, in order for the parents, they have incriminated themselves in what we would call the court of public opinion, right? They're acting sketchy. They lawyered up. The sister lied about the last time she saw him. There's evidence to not only suggest, but to prove. There's photographic evidence and there's documented evidence. They were camping together. So in the court of public opinion, they have definitely incriminated themselves. But in the actual court, in order to be charged as accessories after the fact, they need to know that Brian committed a crime and that then they had to do something that would have prevented his arrest or prosecution. So, for example, if they sanitize the van, for example, if she was shot in the van and they sanitized it after he got home and they helped him do that, then they would be accessories after the fact. If they hid evidence, if they arranged for Brian to travel by buying a plane ticket or renting a boat or giving him money or anything like that, and prosecutors can prove it, then that would be an accessory after the fact. But they have to have known that Brian committed the crime in order to be accessories. It's possible, I guess, that Brian could have said, yeah, Gabby wandered off. I haven't seen her, or she went with somebody else, or she accidentally fell or something like that. And I'll get into a little bit more on that. But that is the answer to that question. Now, remember that we each have a right under the Fifth Amendment to remain silent and to not incriminate ourselves. So the fact that they lawyered up and the fact that they're not talking in and of itself is not evidence that can be used against them. It has to be something else that I previously enumerated. Okay. The next question that I've been getting, or comment that I've seen, is the fact that Brian has taken flight, that he has left. That in and of itself is evidence that he is guilty. The actual, I guess, answer to that, though, is no, it's not. And it's not evidence of guilt, but it can be evidence of something called consciousness of guilt. So let's take a look at this document right here. So this is just, I actually have some experience on this, which I'll get into in here in a second, but consciousness of guilt is a legal term that basically, let me just read this. Consciousness of guilt is both a concept and a type of circumstantial evidence used in criminal trials by prosecutors. It refers to a powerful and highly incriminating inference that a judge or jury may draw from the statements or conduct of a defendant after a crime has been committed, suggesting that the defendant knows he or she is guilty of the charged crime. In other words, the defendant's conduct after the crime is circumstantial evidence that the defendant intended to commit the crime or in fact committed the crime. So some of the most common types of consciousness of guilt are, let's just stop at the first one, fleeing from the crime scene or jurisdiction. Okay, so while the flight in and of itself is not evidence of guilt, it can be used as evidence of consciousness of guilt. And I know in state law, in many states, it's definitely a thing. Under federal law, the only thing that I could find was from the Virginia Law Review from 1979, and it does this article that was written in Law Review talks about whether or not a judge can exclude evidence based on its value of being unfair to prejudice the jury against the defendant. Now, it goes through, behavior to flight, flight from consciousness of guilt, and so on and so forth. So under federal law, which this is surely going to be tried under, the prosecutors most likely, unless it's excluded by the judge, will be able to use the fact that he fled as evidence of consciousness of guilt, not as evidence of guilt. Now, the experience that I have with this, many, many years ago, I would say probably 2002 or 2003, I was summoned for jury duty and I was selected to be on a jury in a case of a double homicide. It was a gang-related double homicide in Sacramento, California, where the defendant, after, well, I don't have to say allegedly, he was convicted of the crime. After gunning down his two victims, he fled. And in that case, the judge actually, in the instructions to the jury, said, you may use his flight as evidence of consciousness of guilt. And let me show you like a sample jury instruction that they use that is very similar to what we received as jurors in that case. It says, if the defendant fled or tried to flee immediately after the crime was committed or after he/she was accused of committing the crime, that conduct may show that he or she was aware of his or her guilt. If you conclude that the defendant fled or tried to flee, it is up to you to decide the meaning and importance of that conduct. However, evidence that the defendant fled or tried to flee cannot prove guilt by itself, which is exactly what we're talking about, right? That his flight is not evidence of guilt. It is evidence of consciousness of guilt. And I have to tell you, according to every prosecutor that I've talked to, jurors really hate it when defendants flee. They just really hate it. So I guess that's my video for today. I hope it was informative. I hope that you guys like this kind of stuff. Man, the case of Gabby Petito is one that we're all watching very closely. Unfortunately, very little, I would say, of evidentiary value is coming out on a daily basis anymore. I mean, it was in the beginning, but it really hasn't for quite some time. But I will continue to keep my eye on this case, and I will continue to update you as I come up with things that I think are valuable for you to know as you're considering the case. In today's conversation, we went over 4 things. The 5th thing that I want to go over though, guys, and this is actually important. I almost forgot this. Sorry about that. People have been asking about whether or not his silence can be used against him. Now, obviously, we all know that we have Fifth Amendment rights. We all know that defendants must be Mirandized, and they know that they have a right to remain silent. But his silence can be used against him in certain ways. For example, if he tries to explain that Gabby committed suicide, and then he went on to be silent, then the prosecutors can kind of probe that, why were you remaining silent if Gabby committed suicide? Or if he tries to explain that Gabby had an accident, she fell and she died, then his silence is incriminating, right? If he tries to explain that Gabby walked off by herself, never to be seen again, or walked off with somebody else, then the silence that he may or may not maintain once he is caught can be used to incriminate him in those circumstances. Silence in and of itself is a right that does not immediately mean guilt, right? But if he tries to use those defense tactics, his silence can be used against him in a court of law. So, okay. So that's the last thing I wanted to talk to you guys about. Thank you very much for coming to the channel. Thank you so much for being interested in the case of the homicide of Gabby Petito. I will keep on it. And with that, I bid you adieu, and I hope to see you the next time. Take care. Thank you very much for watching this video. If you liked what you saw, please subscribe to my channel. And if you have any comments or questions, please leave them below.